So let's start with a few words on the UN Guiding Principles on Business and Human Rights. Human rights have traditionally been understood as rights towards a state. The state is supposed to guarantee human rights, and the state is the only party which can violate human rights. However, there's been a long-term discussion about the impact which businesses have on the enjoyment of human rights. So businesses are influential, and the way businesses conduct their business and conduct their operations has an effect on the extent to which persons are able to enjoy the human rights. So there's been a long-term discussion about that, and the core of the discussion has always been, should there be a self-commitment? Should businesses just say, we want to respect human rights and we oblige ourselves to do that? Or should there be binding laws on business and human rights? Should businesses be legally required to uphold certain human rights standards? In the beginning of the 2000 years, the United Nations have appointed a special representative on business and human rights in order to delve deeper into that issue and to find out what good practices in the area of human rights are. That was John Ruggie. And John Ruggie developed the UN Guiding Principles on Business and Human Rights. Those guiding principles were adopted in 2011 by the Human Rights Council, and they were generally well received. They are a set of principles which govern how businesses should respect human rights in their operations. The UN Guiding Principles are based on 3 pillars. The first pillar is states have a duty to protect human rights. That's nothing new. That's the classic. The party which is obliged by human rights are states. The second pillar states that businesses have a responsibility to respect human rights. So there's no legal obligation. The UN Guiding Principles solved this old dispute between binding regulation and self-commitment to the effect that there is no binding regulation. Businesses are not legally obliged to uphold human rights, but they have a responsibility of which they should be aware. And the third pillar states there should be access to remedy. That means persons who are affected in the way they enjoy the human rights by the way which businesses conduct their operations should have a possibility to make businesses aware of that and to get remedy, to stop the violation of the human rights and to possibly get compensation. The second pillar of the UN Guiding Principles on Human Rights elaborates on the obligations and duties which businesses have when they respect human rights. So they provide a framework on what businesses should pay attention to in order to meet their obligation to respect human rights. And Principle 14 states, the responsibility of business enterprises to respect human rights applies to all enterprises, regardless of their size, sector, operational context, ownership, and structure. Nevertheless, the scale and complexity of the means through which enterprises meet that responsibility may vary according to these factors and with the severity of the enterprise's adverse human rights impacts. And if you are familiar with the German law on due diligence in supply chain, you will find that idea. So the German law on due diligence in supply chains states that businesses have to respect human rights in an appropriate way, or have to take appropriate measures in order to ensure the respect for human rights. And there's been a lot of criticism. What does appropriate mean? The term is not clear. And the German due diligence law provides criteria which businesses have to apply when establishing what appropriate means. What are the appropriate measures which they have to take? And those are the scale and complexity of the business, the sector in which the business are, and the severity of the possible human rights impact. So that has been transferred from the UN Guiding Principles into the German due diligence law. Principle 15 states, in order to meet their responsibility to respect human rights, business enterprises should have in place policies and processes appropriate to their size and circumstances, including a human rights due diligence process to identify, prevent, mitigate, and account for how they address the impact on human rights. And these are in principle the obligation of businesses which are foreseen in the German supply chain law. They have to conduct human rights due diligence. They have to identify risks. That's what's called risk analysis in the German supply chain law. They have to take preventive measures. That's exactly the same which is stated in the supply chain law. And they have to mitigate adverse human rights impacts which have already occurred. And then the UN guiding principles elaborate further on what exactly businesses have to do in order to meet their obligations. And Principle 17 states, in order to identify, prevent, mitigate, and account for how they address the adverse human rights impacts, business enterprises should carry out human rights due diligence. The process should include assessing actual and potential human rights impacts, integrating and acting upon the finding, tracking responses, and communicating how impacts are addressed. And that refers to all adverse human rights impacts that the business enterprise may cause or contribute to. So businesses are responsible for their whole field of operations, not limited to their own activities, not limited to directed suppliers, but it's covering the entire value chain from the moment when the raw materials are harvested or scratched out of the earth and up to the moment when the final consumer puts the product in his living room and uses it. And then the UN guiding principles state, in order to gauge human rights risks, business enterprises should identify and assess any actual or potential adverse human rights impacts with which they may be involved, either through their own activities or as a result of their business relationship. So business enterprises are supposed to find out what are the risks which are combined with our activities. And that means not just what we do ourselves, but also what our business partners along our entire supply chain do. And they have then to assess those risks. And on that basis, they have to find preventive measures in order to ensure that those risks do not become a reality. And the UN guiding principles state, in order to meet their responsibility to respect human rights, business enterprises should have in place policies and processes appropriate to their size and circumstances, including a policy commitment, their responsibility to respect human rights. That means businesses are supposed to give a public declaration in which they state that they're committed to human rights and explain how they ensure that they live up to this commitment and practice. And that's also to be found in the German due diligence and supply chain law, which requires that business give a Grundsatzerklärung, a human rights statement in which they describe their commitment to human rights, in which they describe what risks they have identified, and in which they describe what their expectations are towards their own employees and towards their business partners in regard to the respect for human rights. Principle 19 of the UN guiding principles states that businesses should integrate the findings from the impact assessments across relevant internal functions and processes and to take appropriate action. And then it elaborates on the term effective integration and states, effective integration requires that responsibility for addressing such impacts is assigned to the appropriate level and function within the business enterprise. And that's what you find in the German law on due diligence and supply chains, which requires businesses to appoint persons who are in charge of ensuring that the human rights commitments of a company are upheld. The law states as an example that a human rights officer should be appointed. That's one way of doing it, but at any rate, businesses are legally required to appoint persons who are in charge of upholding human rights commitments. And the root of that is Principle 19 of the UN Guiding Principles on Business and Human Rights. And the UN Guiding Principles state that in order to account for how they address the human rights impacts, business enterprises should be prepared to communicate this externally. And it's also reflected in the German law on due diligence and supply chains. Businesses have to report publicly what they do in order to meet their human rights commitments, what risks they have identified and how they address those risks. That has to be published on their website, and it's also based on a provision within the UN Guiding Principles. And then the UN Guiding Principles have a third pillar, which deals with access to remedy. And in this pillar, the UN Guiding Principles distinguish between state-based mechanisms and non-state-based mechanisms. State-based mechanisms might be things such as court proceedings, where victims of human rights violations can gain compensation or can take action in order to stop the violation of the human rights. And there are non-state mechanisms, and that means mainly grievance mechanisms run by companies. So the UN Guiding Principles foresee that companies, business enterprises put in place mechanisms which enable persons who are affected by violations of the human rights to draw the attention to that and to tell the business, our human rights are violated, please do something about it, take action. So in summary, the UN Guiding Principles provide for a number of obligations which business enterprises have to meet in regard to the respect for human rights. And those obligations apply to all business enterprises. And those obligations do not only concern the own activity of the company, but companies are also responsible for effects of the operations along the entire supply chain on both sides, upstream and downstream. The UN Guiding Principles were met with high expectations. So many people, they were well received, and many people thought that is a breakthrough, and now the entire landscape in the area of business and human rights is going to change. That did not happen. That did not happen. And since that did not happen, there was a new discussion about binding regulations. More and more people said, so the UN Guiding Principles did not really work the way we were hoping. That means probably we still need binding legislation. And that's an international trend. More and more countries are passing binding laws in regard to the human rights implications of the activities of businesses. In Germany, as a consequence of that discussion, the Due Diligence in Supply Chains Act was passed, the LkSG. And if you look at the law, it basically states to which companies it applies, which companies are in scope. It states which interests it protects. So in regard to which rights companies have obligations, it elaborates on the obligations and duties of companies, what do companies actually have to do, and it foresees some rules regarding enforcement. The German due diligence and supply chain law does not apply to all businesses, but only to business enterprises of a certain size. You're probably aware of that. There's a threshold of 3,000 employees since January 2023, and this threshold will be lowered in the beginning of 2024 to companies with 1,000 employees. So these companies have to fulfill the obligations deriving from the due diligence in supply chains. And another difference is that there are rules regarding enforcement of the law. Those are not existent in the UN Guiding Principles because the UN Guiding Principles are not binding, so they cannot be enforced in that sense. The obligations of companies are, as I already pointed out, taken over from the UN Guiding Principles. They are structured in a slightly different way, and sometimes there are some redundancies in UN Guiding Principles, and the German legislator has tried to phrase the obligations a bit differently, but at the core, the obligations are the same. So companies have to appoint persons who are in charge of the risk management within the company. They have to devise a system of risk management. That means a system which ensures that human rights risks do not turn into a reality. They have to conduct a risk analysis. They have to establish what risks are, exist in connection to their activities. They have to take preventive measures. That means measures which ensure that on the basis of this assessment of risks, no human rights are violated. They have to give a human rights statement. They have to take mitigating measures in cases in which human rights violations have already occurred. They have to document what they are doing in that regard, and to have to report publicly about it. And last but not least, they have to establish a grievance mechanism. They have to establish a channel which enables affected persons to report about the way in which their human rights are affected by the operation of that enterprise. So the obligations are in principle the same as in the UN guiding principles. However, they are limited in scope because according to the German due diligence and supply chain law, this obligation exists primarily regarding direct suppliers. So companies do not have to look along their entire supply chain, but in a first step, they have to look at their direct suppliers and identify risks, take preventive measures, and so on. The only exception to that is the grievance mechanism. The grievance mechanism applies, or the obligation to establish a grievance mechanism applies from the very start along the entire supply chain. So according to the LkSG, German companies, which are in scope, have to ensure that a grievance mechanism is available along the entire supply chain, direct and indirect suppliers. These were the developments on a German level. And this discussion about binding regulation is also reflected on the plane of the EU. In March 2021, the EU Parliament adopted a resolution in which it asked the Commission to pass a directive, a EU directive, which would oblige member states of the EU to pass binding legislation regarding human rights obligations of companies. On that basis, the EU Commission delivered a proposal for such a directive in February 2022. The Council of the EU provided a statement on that, or commented on that, or gave its own position on that proposal in November 2022. And then in turn, the Committee for Legal Affairs of the EU Parliament passed a resolution in April 2023 in which it gave a suggestion on how the plenary of the EU Parliament should vote regarding the position of the EU Parliament. And there should be a discussion in plenary of the EU Parliament that should be today or tomorrow, and then there will be a vote probably in the first days of June, 1st or 2nd. I don't quite remember. So now the EU Parliament is going to state its own position, and this will lead to the so-called trilogue negotiations. That means negotiations between the EU Council, the EU Commission, and the EU Parliament on the way this directive will look like. At some stage, the directive will be adopted, and then member states will have a 2-year period to transfer that into their own legal system, or to transpose the obligations which are foreseen in the EU directive into their own legal system. This draft EU directive is structured in a very similar way to the German due diligence and supply chain law. So it establishes which companies are in scope, to which companies it applies. It then states certain duties of those companies. What do the companies have to do in regard to business and human rights, in regard to their environmental obligations? And it also foresees regulation regarding the scope. That means how far do these obligations reach? Do they just extend to direct suppliers? Do they go along the entire value chain, and so on and so forth? It then provides which interests are protected. So in regard to which rights and which environmental standards do companies have those obligations. It foresees rules for control and enforcement. It foresees sanctions, and it foresees civil liability. So the structure is very similar to the German due diligence and supply chain law. Regarding the companies which are in scope, there are different positions. First of all, the German due diligence and supply chain law makes or just refers to the number of employees. So whether or not the law is applicable depends on how many employees a company has. The EU foresees a threshold on the basis of number of employees and turnover. So the number of employees is not the only factor which is going to be considered when it comes to determining whether or not those EU directive is applicable. It refers to EU companies which are registered in the EU, and companies which are registered in third countries, but which do business in the EU. And for those companies, third country companies, the applicability of the directive depends on the turnover. So in that case, the number of employees does not play a role. And then there is a debate whether or not the directive will apply to all kinds of companies, or just to companies which have some sort of limited liability according to the respective laws of the member states. So the Legal Affairs Committee says all companies should be in scope. The Commission and the Council says we should only talk about companies with some sort of limited liability. And there is a debate whether or not financial companies, that means mainly banks, insurance companies, investment companies, should be in scope or not, or should be exempted, or if they should be exempted in some way. There's a plan to vary the thresholds according to the sector in which those companies are active in. And the Commission foresees that different thresholds should apply for enterprises which are active in high-risk sectors. There are sectors which are considered as particularly hazardous with regard to human rights and the environment. And the Commission foresees to have lower thresholds for such companies. Those sectors are textile, agriculture, and the extractive sector. And that's for companies which are active in these fields. The Commission foresees that the directive should apply if they have 250 employees and a turnover of 40 million. The Council agrees in principle with these thresholds. However, it says it will be hard for companies, it will be hard on companies to put that into practice in such a short period. So they want to introduce a transitional period during which the directive will be applicable to companies with 1,000 employees and 300 million in revenue. And the Council says there's the applicability to financial companies, banks, and so on should depend on the member states. So they want to leave that decision up to the member states, and member states can then decide whether or not they want to apply the national law, which they pass on the basis of this directive, to financial companies or not. The Committee for Legal Affairs foresees a threshold of 250 employees and 40 million euro revenue. And that's a novelty. It foresees an attribution to the top. So if you're familiar with the German LkSG, you will know that it contains rules for groups of companies in which the employees which work for one member company of this group of companies are attributed to the company on top, the mother of the group, so that all the employees within the group are basically counted together. And then if that reaches the threshold of 3,000 or 1,000 company employees, the law is applicable. Regarding the duties, those are in principles the same as foreseen in the UNGP principles and as foreseen in the LkSG. There has to be a risk management. Companies have to conduct risk analysis. They have to take measures to prevent the realization of risk, and they have to mitigate them once they have occurred. And they have to introduce a grievance mechanism. In addition to that, they have to monitor the effectiveness of their measures, and they have to document what actions they take, how they fulfill their obligations, and to report on that publicly. There's a difference of an opinion on the question to what suppliers those obligations extend. So what should the reach be? The Commission says companies should be obliged regarding their entire value chain. That means upstream, businesses which deliver to the company which is in scope, and downstream, that means basically clients of the company which is in scope. So companies, according to that, will have to look at all of their suppliers along the entire supply chain, and they will have to look at all of their clients along the entire chain of distribution of the product. And the Commission wants to limit that to an established business relationship. That means only business relationships which have some duration, are not entirely ancillary, direct or indirect. The Council wants to apply those obligations only upstream, so only to my suppliers, but suppliers, direct suppliers as well as indirect suppliers. So according to that, businesses will have obligations regarding their entire supply chain, everything upstream, including design, production, transport, storing, etc. And the Committee for Legal Affairs, and probably following that, the EU Parliament, want to apply those obligations along the entire value chain. That means upstream and downstream. And for all kinds of businesses you have a business relationship with. So very far-reaching obligations. Then the directive sets out what the protected interests are. So in regard to what rights and what environmental standards do I have to conduct my risk assessment? What should I take into the possible violation of which rights constitutes a risk? And the directive specifies that in two ways. First of all those standards and rights are listed in an annex to the directive. And this annex has two parts. The first part lists specific rights. So, for example, it names forced labor. That's a risk, and companies have to conduct a risk assessment in regard to the risk of forced labor. And in addition to those individual rights, it also refers to international treaties. That's part 2 of the annex. And then the directive says, in addition to that, companies also have to pay attention regarding the rights which are enshrined in the international treaties named in the annex part 2. And there's a disagreement what international treaties and what rights should be listed in that annex. The Commission and the Committee for Legal Affairs both want to put a large number of international treaties and declarations on human rights. So there's a large list of international contracts, and those are the ones with respect to which business enterprises are obliged. The Council says we should limit the number of treaties and the number of rights which are listed in the annex, and we should only refer to binding treaties signed by all member states. So in the Commission and the Committee for Legal Affairs, in their draft, you have a very long list of international treaties, and in the version of the Council, you have a much shorter list. Both suggestions or both proposals go way beyond the LkSG. So they reference way more rights, way more international treaties. So the burden on company or will be higher, so to speak. The EU directive is much stricter in regard to environmental standards. It foresees that companies which have identified carbon emissions as a risk of their operations have to commit to the 1.5 degrees climate goal from the Paris Climate Agreement. They have to align the business model and strategy with the goal of a sustainable society. And that goes beyond the provisions of the LkSG, in which the environmental standards are a bit short or are given short shrift, more or less, and only some very basic standards are referenced. Here, much larger number of international agreements regarding climate change. The big step beyond the obligations of the LkSG is that the directive foresees civil liability of enterprises. So if a company violates a duty and is at fault, acting negligently or with intent, and because of that, a damage is caused, the company will be forced to pay compensation, or the other way around, affected persons must have the right to sue the company, to submit a civil action, and to ask the company or to try to force the company to pay compensation. And there's one more dispute. The Commission wants to introduce a provision on remuneration. It says that the fulfillment of duties regarding sustainability must be a factor when deciding upon the remuneration of management. The Council and the Committee for Legal Affairs say that's nothing we should take care of as the EU. The board of each company should fix the remuneration of management, and it's not on us to give guidelines in that regard. And finally, member states have to foresee fines, and each member state has to put in place authorities which control and enforce the provisions of the EU directive or the law which is passed on the basis of the EU directive. And the authorities between the member states shall collaborate to find a joint policy and to find a joint way of enforcing that. So if you compare the Corporate Sustainability Due Diligence Directive with the UNGP, there's a difference. The number of companies which are in scope is limited. UNGP applies to all companies, no matter what. EU directive only to a limited number of companies, and what exactly the criteria will be remains to be seen. The duties or obligations of companies are in principle the same in the LkSG, in the directive, and in the UN guiding principles. The only difference is that the EU directive possibly will limit the scope. That means it does not apply to all operations of the companies and all kinds of risks they contribute to in some way, but it might be limited to one side of the supply chain, only upstream. A difference is that enforcement is not foreseen in the UN guiding principles, and the difference is that civil liability is not foreseen in UN guiding principles, but even the UN guiding principles recommend that there should be a way for persons who are affected by human rights violations should get compensation. So, as I hope becomes clear from what I said, the UN guiding principles are the blueprint for regulation in the field of business and human rights. And that does not only apply to the German supply chain law and to the EU directive, but also to other laws which have been passed in other countries. For example, the Loi de Devoir de Vigilance, which have been passed in France. So all those international regulations go back in some way or the other to the UN guiding principles for business and human rights. And even when the regulation itself is not based on UN guiding principles on human rights, it usually refers in some way or the other to the UN guiding principles. An example is the Uyghur Forced Labor Prevention Act, which has been passed in the US. So since a long time, the import of goods made with forced labor is prohibited in the US. And since last year, the Uyghur Forced Labor Prevention Act applies, and that's a new law, which establishes a presumption that goods originating entirely or in part from the Xinjiang region are made with forced labor. So if something comes from that part of China or is made with parts which come or are likely to come from that part of China, then the US authorities assume that it has been made with forced labor and it must not be imported into the US. That's a presumption. And companies are given the opportunity to prove the opposite. They can rebut the presumption. And the question is, how can they do that? And there's a guidance passed by the Customs and Border Protection of the United States on what companies can do in order to rebut that presumption. How can they demonstrate that forced labor was not used in the production of those goods? And this guidance refers to the UN Guiding Principles on Business and Human Rights. That means they say, show that you have implemented UN Guiding Principles. And if you have taken all the steps which are foreseen there, that's one way or one step in demonstrating that forced labor has not been used to produce those goods. So the conclusion is that there are differences between those regulations passed in various countries and UN Guiding Principles on Business and Human Rights. But the intellectual basis for all of them are the UN Guiding Principles. And people often ask, so if I comply with the LkSG, will I be fine regarding this EU directive? And the answer is probably not, but you will be fine if you apply the UN Guiding Principles. And then there will be differences in the way companies have to report, or the way or the consequences if they don't comply or something like that. But the principles are always the same. So if you want to look at something to be on the safe side, look at the UN Guiding Principles. Concrete steps you could take in that regard: appoint human rights officers and persons in charge in relevant areas of the company. That's something which is foreseen in the UN Guiding Principles. You have to have a team of persons who take care of that in the long run. We are in charge of the business and human rights obligations of this company. Equip them, give them time to do their work, and train them so that they know what they're doing. Those people should develop a long-term strategy on how to implement the UN Guiding Principles. That's nothing which is done within a couple of weeks. That's a long-term project which should be revisited regularly, but there should be people who say, okay, we work on that issue and we develop a long-term plan on how to implement the Guiding Principles. Communicate internally about that issue so that the employees are on board for that, and that they know our company is taking steps into that direction, and that they wonder how they can support the process. Get an overview over your supply chain. So right now, you have mainly to look at your direct suppliers if the LkSG is applicable to you. That won't be enough in the long run, and it's not even enough under the LkSG, because you have to implement this grievance mechanism along your entire supply chain. So it's not easy to get that overview. That's also a long-term project, but in the long run, you should try to map where do my products come from ultimately, and where do they go. Engage with stakeholders. Speak to affected persons. Many people see the implementation of the UN Guiding Principles and of those law as a sort of tick the box exercise. We have to do that. We have to obtain these documents. But it's really a matter of meaningful engagement with affected persons. Talk to them. Establish a grievance mechanism. Atlat can help you with that. That's something which, first of all, is a means for affected persons to get remedies, but it's also a means for your company to find information about human rights risks, about aspects of your business you have not seen. And finally, see the LkSG as a testing ground. If you do everything the LkSG demands, that won't be enough in the long run, but you can try certain practices, see what works and what doesn't work, and then apply it on the larger scale in order to meet the obligations of the directive and of the UN Guiding Principles.